Dividing assets and debt in mediation is not as difficult as it might sound. Where do we start? We start by identifying the assets. That might sound simple, but it isn't always. One spouse may have more visibility to what the assets are, and so we're relying on both spouses to share with us what the assets are. Tax returns also tell stories. Oftentimes we'll see dividend payments and interest payments, and then we say, wait a minute, where'd this come from? Where's the account? And then they say, oh my gosh, I missed it. Yes, there is an account here. So first we're gathering assets. Then we're looking at the other side of the ledger, if you will, and we're looking at liabilities. What debt do you have? Do you lease cars? Do you have credit card debt? Besides your mortgage, do you have a home equity line of credit? Are there student loans? Are there parent loans where you funded your children's education? Are there unpaid medical bills? We go through all of that to essentially build a marital balance sheet. What do we have on the asset side? What do we have on the liability side? And then we start to determine what is the fair and equitable way to share both sides of that equation. Can one spouse have everything in the divorce? Well, that is such an unlikely outcome. If that's your position going into mediation, you're sadly going to be disappointed with the process. Nobody wins the game of everything in mediation, just like nobody wins the game of everything in court. In all of the cases I've seen in my career, there's never been a case where a judge simply says one spouse gets 100% of everything. And by the way, custody of the kids too, right? It's just an unrealistic position. So if you've read something online where you heard that there's this way that you can have everything, it's simply not true. And you are going to spend months and months, if not years, of wasted energy and thousands upon thousands of dollars advancing an unreasonable position. Would we take on a mediation where one side says, I want everything? If we can't dissuade them from that position at the onset, we'd be stealing your money and we wouldn't mediate the case. You have a complex property dispute and you're wondering, can my mediator even help? Of course we can. Whether the assets are titled into LLCs, whether the assets are shared with family members or business partners, or you have assets spread across the country, our mediators are skilled in complex litigation, which means we are also skilled in complex mediation, and we can divide and help the parties reach a resolution even when the assets are complex. Who gets the house and who has to move out? And you're in mediation, who decides? Well, you decide, because remember, your mediator is not a decision maker. Your mediator is helping you navigate the process. Your mediator is going to vet pros and cons of everybody's position and help you reach a resolution. Oftentimes, the who gets the house might be tied to the children. It might be tied to who can actually afford the house post-divorce, or it might be tied to a pivotal moment in the children's life. So for instance, the primary parent has the children, they're living in the house, and the primary parent says, wait a second, we have a child that's graduating high school in 6 months. Why would you have that parent move with the child? So sometimes there's a moment in time, a moment in the children's life that's so pivotal that you agree to either delay the sale of a house or delay the transfer of that asset to another party to allow the child to graduate, for instance, from high school, stay in the home that they know, and stay in the town that they've become accustomed to. If you have any questions about how you divide property in mediation, or can you divide your property in a mediation setting, give our office a call and one of our teammates can walk you through the process, tell you what mediation is, what it isn't, and what issues we can cover in mediation.